Freedom of speech is a right that was given to each person in the First Amendment to the United States Constitution. This right is an important one. I'm going to focus on the right to free speech and its importance in regard to students. Today, I will introduce a few of the landmark Supreme Court cases that involve student speech. The one I'd like to begin with is the most well-known. The story began in 1965. Have you heard of the case called Tinker v. Des Moines? This case took place because one middle school student and two high school students decided to wear black armbands to school in protest of the Vietnam War. According to Susan Dudley Gold, author of the book Tinker v. Des Moines, Free Speech for Students, the group that had been planning on wearing these armbands released the information about it to the public, hoping that others would join. When the school found out about these plans, they immediately made a rule that no student could be allowed to wear the armbands. The three kids, whose parents were very involved in the protest of this war, put the armbands on anyway. When school administrators realized that the students were wearing armbands, they were suspended. Feeling that their First Amendment rights were being trampled on, the three students and their parents contacted a lawyer to pursue the matter in court. These three students, John Tinker, Mary Beth Tinker, and Christopher Eckhart, were changing history. The case eventually ended up in the hands of the Supreme Court. Gold notes that on February 24, 1969, the Supreme Court Chief Justice, Abe Fortas, made the following famous ruling. It can hardly be argued that either students or teachers shed their constitutional rights to freedom of speech or expression at the schoolhouse gate. Gold suggests that this ruling is the broadest statement of students' rights yet rendered by the Supreme Court. The court also insinuated that as long as the students' actions did not disrupt classes, they had as much right as adults to free speech. It is reasoned by Gold that the ruling in this case set a standard that has been used to judge almost all other questions involving students' rights. In the years that have followed the decision, school administrators, students, and courts have referred to the Tinker case when deciding what limits should be applied to student newspapers, yearbooks, magazines, demonstrations, and other student activities. Tinker has been popular because the ruling was in favor of the students. However, the next two landmark cases I'm going to talk about did not work out so well for the students. The court found ways to restrict students rather than giving them freedom. The second important landmark case is called Hazelwood School District v. Kohlmeyer. In an article by Steve Weiser, the author reports that students Kathy Kohlmeyer, Leslie Smart, and Leanne Tippett West sued their high school, Hazelwood East, in 1983 when the principal, Robert Reynolds, censored a 2-page special section on teenage problems from Spectrum, the school newspaper. The stories were about divorce, runaways, and teenage pregnancy. Weiser explains that those against the school administrators believed that Reynolds censored the writing because he wanted to cover up problems that might ruin the school's excellent reputation. His belief is that Hazelwood v. Kohlmeyer goes to the core of a school's mission to prepare students socially and politically for democracy. Based on the research of a journalist named Mark Walsh, the court ruled in favor of the principal, saying that the officials did not violate the First Amendment when they exercised editorial control over the content of student speech in school-sponsored expressive activities as long as their actions are related to legitimate instructor concerns. The third and final case I'm going to talk about is considered to be the first to belittle the rights that were set by Tinker. It's called Bethel School District v. Frazier. Journalist Mark Walsh writes that this case ended up in the Supreme Court because in 1986, Matthew Frazier, a senior in high school, had written a nomination speech for a friend that included sexual innuendos, which resulted in Frazier getting suspended from school. The administrators had thought it was too inappropriate for school, but Frazier says that he was just doing it for laughs from his peers. Frazier was quoted in Walsh's article saying, "If election assemblies are not the one place where kids can speak and push the boundaries a little bit, then what lesson does that teach?" Walsh concludes that the Supreme Court, however, did not agree. The justices ruled that a school district did not violate the First Amendment rights of a high school student when it disciplined him for giving a speech that was full of sexual innuendo at a student assembly. Chief Justice Warren E. Burger also noted that the constitutional rights of students in public school are not automatically coextensive with the rights of adults in other settings. This statement is completely contradicting the Tinker ruling. Free speech issues have always been around. The students of the past have shown bravery in defending themselves against what the school was doing. Speech rights given to students from the Tinker case are slowly diminishing. Current students need to stand firm for their rights even in the face of controversy.